Hi, you're listening to the Lawyer Society Legal Podcast for lawyers, practicing advocates, law students, and judicial exam aspirants. What if a false Pocso case has been registered against the husband, the father, by his own wife so that she can influence the mind of the family court judge who is hearing a maintenance case or is hearing a custody case? In the case of a maintenance case, it is obvious that a filing of a false FIR can influence the husband into settling some large amount to the wife, which she would not have done in the absence of an FIR against him. And the wife will be of the mindset that she will withdraw the false Pocso complaint when he surrenders to her needs, when he accepts to settle a larger amount than what he would have wished to settle. In the case of custody battles, this might influence the family court judges into thinking, okay, here is a father who is allegedly sexually harassing the child or who has once sexually harassed the child. Now I can't grant him custody or visitation rights, and it would not be in the best interest of the child to do so. So I am denying him custody or visitation rights. Now this is happening across India, so there are obviously various citations available across the courts and different remedies that have been developed in order to prevent such false Pocso cases from being registered. And even if they are being registered, there are various remedies available to a husband at different stages, and they can be split into two. Basically, you have remedies on the criminal side, and on the other hand, you have remedies on the family court side. On the criminal court side, you have the first remedy of availing anticipatory bail, which is pre-arrest bail. And in case of a Pocso offense, this is pretty difficult to get, but you have some cases where AP has been granted to the husband because the court was able to look at the family court proceeding which was pending and infer from the material that the husband was able to produce that this Pocso case might well be a false case made just to influence the family court proceedings. Also, if he has been arrested and you are going for bail, the same can be done. On the other hand, you can also go for quashing the FIR at an early stage. Now, quashing an FIR at an early stage is pretty difficult, but it has been done. And to do all this, you have to look at the 164 statement of the victim, where she might have confessed that the mother has made a false case, or she might have confessed the non-existence of any sexual harassment on part of the father, or the necessary ingredients were not made out in the 164 statement. If the 164 statement does not help the father's case, then the criminal court can be shown the existence of the family court proceeding, and suppose say the family court proceeding was slightly in favor of the father and it was about to pronounce an order in favor of the father, and in such circumstances the Pocso case was registered. The same can also lead the criminal court into granting AB or into granting bail or into quashing the Pocso case. Also, it is possible that other materials can be shown. The fact that, say, the question of why the wife did not raise such allegations against the husband previously, and in case of a custody battle, she could have well raised the same complaint or same allegations against the husband well in advance. But the custody case has been pending for several months or even years, and it is only now that she has raised such an allegation against the husband. So all this can be shown to a court in order to influence or in order to bring to its knowledge the fact that this Pocso case is a false case. Also, on the family court side, it is possible to argue that mere registration of a Pocso complaint cannot be taken as the only ground to deny custody. In this regard, you can also refer to the case of Suhara versus Muhammed Jaleel, where the Kerala High Court had specifically held and laid down certain guidelines to ensure that the family courts are not influenced by the pending Pocso cases. Here it was said that in the absence of any reliable corroborative material, the family court should not rely only on the FIR in order to deny custody to the father. This has been subsequently followed by various other high courts, and also the Kerala High Court has reiterated the same position in its subsequent decisions where it dealt with similar facts and circumstances. In the case of Chandramohan versus State, the Madras High Court had looked at the 164 statement of the victim, where she had stated that the mother had cooked up a false story so that she can influence the family court, and the Madras High Court quashed the FIR filed against the husband and directed the police to proceed against the wife under section 22 of Pocso, which is the offence of registering a false Pocso case. If you want a much more detailed opinion on this, you can read the February issue of the Lawyer Society Digital Law Magazine, where I have written about this in detail. Now, thank you for listening. Please do follow us on Spotify. Please do subscribe to us on YouTube. Thank you.